In this short video, we're going to have a look at an evaluation essay on attempts. Evaluation essays appear on exam 3, and on exam 3 you'll have to answer 3 essays in total, 1 criminal, 1 contract and 1 tort. So this is a possible question that could appear on the criminal section. The question is, discuss whether the Criminal Attempts Act has improved and clarified the law on attempts. 25 marks, and you would have 45 minutes to answer that question. So in this particular essay, you're going to have to explain what the law on attempts is, AO1, but also to evaluate the law on attempts and whether it is better now than it used to be since we've had the Criminal Attempts Act, and that would be your AO2. You get more marks for your AO2 on these essays than for your AO1. So this image that I've got in my document is to illustrate the very important case of Geddes, which we're going to discuss later. And the reason I've put this here is just to remind you that one of the big issues, the big problems with the law on attempts is the very controversial case of Geddes. And that case illustrates a major problem with the law on attempts even after the 1981 Act was made. So the general gist of this essay is going to be, yes, the law is better than it was, however, there are still problems. So if we have a look at the suggested answer here, as usual, the AO1 is in black font and the AO2 is in red font. And as usual, you see that we explain some law and then we evaluate it. And that just makes sure that your essay has a nice structure and that you're maximising your AO2 points. So as an introduction, I've started with a definition of what a criminal attempt is. And a criminal attempt, of course, is where the defendant tries to commit a criminal offence but doesn't complete it for some reason. And that might be because they're apprehended or they're not competent enough to do it. For instance, they don't put quite enough poison in someone's drink, or they're thwarted in some other way. But they've tried to commit the offence, and so therefore we want to prosecute. The Criminal Attempts Act 1981 was created to improve and codify the law on attempts. Before this Act of Parliament, it was common law, so it was judge-made law. There weren't really any clear definitions and there were lots of tests. So this Act was created to make some improvements. But as I said previously, there are still problems with the law, which we'll discover when we explain what the law is. So it's logical, because the question's asking you about whether the Act has improved the law. I'm going to highlight that there. We're being asked if it's improved it. In order to answer whether it's improved it or not, we have to look at what was the law before, what is the law now, is it better? So, as I said, before the Criminal Attempts Act, it was governed by the common law, and there were lots of different tests which were used to decide whether a defendant had committed a criminal attempt. Some judges used the last act test. So that was where the judge said, have they done the last possible act before committing the actual offence? Others used the Rubicon test. And that comes from a very old-fashioned phrase where the judge said, have they crossed the Rubicon and burnt their boats? And that means, have they reached the point of no going back? And then other judges used the series of acts test, where it said that to be guilty of a criminal attempt, you had to do not just one thing, but a whole series of things. Now, just from describing those 3 tests, you can see that they're problematic because they're all vague and they're not clear. As I've put here, my evaluation points, it's confusing to have a number of different tests. It'd be much better if there was just one single test. And of course, they're not very clear either. So it was difficult to decide at what point has our defendant gone beyond planning and has committed an actual attempt. I've abbreviated now to the CAA 1981. That, of course, means the Criminal Attempts Act. So the idea behind this act was it was going to address this rather blurry line. But unfortunately, it's doubtful how much it's done that. So now's a good point to consider the Criminal Attempts Act. If we turn to section 1, subsection 1 of the Criminal Attempts Act, it states that an attempt is committed where the defendant does an act which is more than merely preparatory. I might just change the colour of that because that's important. I'll make it bold as well. So you've committed an attempt where the defendant does an act which is more than merely preparatory to the commission of an offence, and also he has the mens rea for the offence that he's trying to commit. So more than merely preparatory means you have more than merely prepared. And I suppose that's a little bit clearer perhaps than the other sort of vague concepts of burning your boats. And this is the test that we're now supposed to use. Case of Gulliver was the case where the defendant was losing on a dog race and he decided to jump on the track in order to try and recover his stake, his bet. He didn't actually get to the point of asking for his money back. So the issue was, had he completed an attempted theft or had he not? And in that case, they thought that actually he had not. But what was quite interesting was the judge, it was Lord Lane in this case, felt the need to clarify the test further. So here we've got this test that is supposed to be clearer than these tests, and the judge in Gulliver has now added another test, and I'm going to do that one, I'll do it green. The judge said that more than merely preparatory means the defendant must have embarked upon the crime proper. They must have actually started the crime that they're being charged with. And in Gulliver, they said, well, he hasn't started the offence of theft because he's not gone to go and appropriate the property yet, the money. Now, we could put a critical or an evaluation point here because you could say, although this is not the official test, you still have a judge adding another test to the mix, which is what Parliament sought to avoid when it created the Criminal Attempts Act. So already we're trying to avoid these 3 tests, and now we've got another 2 tests. So already we've got some concerns here. So another evaluative point I've made is that although this more than merely preparatory test was supposed to allow for more common sense decisions, the case law suggests that it's not always as simple to apply as you might think. In the case of Boyle and Boyle, the defendants were caught trying to burgle a house and they'd actually broken the hinge on the door. And in that case, I think we were quite right there, but that was held to be more than merely preparatory. They had more than merely prepared because they'd broken the hinge on the door. Interesting though, if you compare it to Tosti and White, Tosti and White was where the defendants examined a padlock on a shed, and they also had some cutting equipment hid in a hedge, but they were disturbed before they could do anything further. Now, in that case, all they'd done was touch the padlock. They hadn't cut anything, they hadn't broke anything, which of course is different to Boyle and Boyle. And yet they were found guilty of an attempt as well. You might say that that's fair enough. I think it probably is. They have gone beyond preparation, they've got the equipment, etc. However, it is possible that some people might say that these decisions are inconsistent. The defendants in Tosti might have changed their minds. Tosti is also quite hard to reconcile with the case of Campbell. And we could well add this in. This is another point I've thought of as I'm going through. But if we come to Campbell, in that case, the defendant was dressed in what you could say was a disguise because he still had his motorbike helmet on. He had an imitation firearm in his pocket and he had a threatening note in his pocket as well. And he was about to rob a post office. However, he'd not gone into the building yet, and so the court said that his acts were merely preparatory, so he hadn't committed an attempt. That does seem a bit strange when you compare it to Tosti and White, because in Tosti and White, they hadn't gone in yet. In Campbell, they haven't gone in yet. They've both come equipped, and yet they're guilty, he's not guilty. And I might just pause this and add that point in for you here. Okay, so I've added that in. If you have a look at my evaluation then of Campbell, I've said that Campbell can be criticised because it seems clear what he intended. I mean, he had a note in his pocket. It doesn't get much clearer than that. And I've added in here that Campbell also conflicts with Tosti and White because the defendants were guilty in Tosti and White where they'd not entered the shed, but of course he's not guilty where he's not entered the post office. So this shows that the test can produce inconsistent decisions. Another problem with this more than merely preparatory test is that it requires a level of confrontation, as you can see in the cases of Jones and Geddes. In Jones, he had to get in the car and point a gun at someone's head before the action was more than merely preparatory. And in this famous case of Geddes, the guy was fully equipped, waiting, lurking in a toilet, and that was simple preparation. So these cases illustrate a problem here, particularly Geddes. So Geddes seems unfair because the defendant would have had to have touched a child to be convicted. So this more than merely preparatory test is allowing a criminal to lurk in toilets and go unpunished, suggesting that maybe a different terminology other than more than merely preparatory might be better. And the Law Commission has made a recommendation on that, which you can see I've put there. I've dealt with the more than merely preparatory test. I'm now going to consider the law on attempting the impossible. So the Criminal Attempts Act has improved the law on this because, as you can see, before this act, if the crime was impossible to commit, then there was no offence. Now, of course, thanks to section 1, subsection 2, you can be guilty of attempting the impossible. And of course, this seems right because if you think about the case of Orrin White, he didn't use enough poison, she was going to die anyway. It would seem unfair if he could escape liability just for being a bit incompetent at carrying out a crime. Equally, if you stab a pillow, thinking it's a human, you still have that high-level mens rea. The fact that you were lucky that the person wasn't there shouldn't mean that you escape liability. Remember, the law wants to protect society from potentially dangerous individuals, so it's important that we can prosecute for attempting the impossible. Despite that improvement, you could talk about Anderton and Ryan. Anderton and Ryan, the House of Lords, didn't actually comply with section 1.2. And that illustrates the problem here that the courts were worried about the fact that you're dangerously close to prosecuting people for their thoughts rather than their actions. But we have a clear answer from Shiv Puri now. Shiv Puri overruled Anderton and Ryan. And of course, whenever you've got courts overruling themselves, that illustrates that the law is problematic. Mens rea is also a little bit problematic. You could talk about the case of Wybrow, so that for attempted murder, you have to have intention to kill, which sets a higher standard because for murder, you only need intention to cause GBH. And I've put the practical reason for that there. And then the conclusion, I'm summarising what I've said here, that the law is better than it was. We've got one test now, but the test is still a bit problematic. It's good that we've got attempting the impossible, although there's been a little bit of a problem there with Anderton and Ryan. But we do still have some difficulties, and a good way to conclude is the Law Commission recommendations. So they want to clear it up and separate two slightly different offences of attempts, which you can see just there. and that would improve the law.